Hello, and welcome to Administrative Remedies, because you can't fix what you don't understand. Brought to you in part by the University of Tulsa College of Law. I'm Gwendolyn Savitz, an associate professor here at TU and the Associate Dean of Research and Intellectual Life.
And I'm Mark Rourke. I'm the Dean of the College of Law.
We'll be breaking down complex doctrines with real-life analogies and examples to demystify the world of administrative law for everyone trying to understand how government actually works.
Agencies are the main way the federal government gets things done. It's not through Congress, for reasons we'll be addressing over the course of this series.
We said we would record an episode after Slaughter was decided. Slaughter has now been decided. So we're doing this episode today, and we're going to do another episode on another recent Supreme Court case that will come out this next Tuesday. And then we will take a break before we finally start season 3 officially in August. So, Slaughter. For those who missed the background, in 2018, the Senate confirmed Rebecca Slaughter to the Federal Trade Commission unanimously. She had been nominated by Donald Trump. This wasn't because she was a Republican. She wasn't. She was Democrat. But it was because the FTC was required to have members from both political parties, and she was needed as a Democrat. Then in March 2025, when Trump resumes the presidency, he fires her. And the letter he uses to do this doesn't allege inefficiency or neglect of duty or malfeasance, the 3 grounds the statute gives for removing an FTC commissioner. It said that her service was inconsistent with my administration's priorities. He also fired the commission's other Democrat, Alvaro Bedoya, the same week, and that left the body that Congress had built to be bipartisan with only 2 members, both from the president's own party. And he was doing this specifically to challenge what had been settled administrative law for decades. And on Monday, the Supreme Court said that all of this is constitutional.
That settled law was Humphrey's Executor from 1935. Roosevelt had fired an FTC commissioner named William Humphrey for more or less the same reason, wrong politics, and the court told him he couldn't. The case is named for an executor because Humphrey died before it was decided, and his estate finished the lawsuit for him. But that holding stood for 90 years.
Yes, and now it's gone. It's explicitly overruled in an opinion handed down on June 29th. The opinion was Trump v. Slaughter. The decision was 6-3, and the court didn't mince words. It didn't limit it to the facts. It said the case was wrong the day it was decided.
Last year, it reached the court on an emergency docket, a stay application, and the majority let the firing stand for the moment. We covered it then, and what stuck with me was that even in those emergency orders, the court went out of its way to say the Federal Reserve might be different. Hold that thought, though. We said back then this would be the case that decided whether Humphreys lived. This is that decision.
Right. More specifically, we said this would be the case where Humphreys died. And this is part of a broader picture. In Season 1, we talked about the court limiting what agencies can decide. Through Loper-Bright, through the Major Questions Doctrine. Season 2 is the court limiting how they can adjudicate, cases like jarczy. This is the front after those. It's not what they decide, it's not how they hear it, but it's who controls the people doing both. We used to have independent agencies, now we don't.
So this is the wall that's coming down.
Exactly.
Okay, let's work through it systemically. What protection did Slaughter have exactly?
One clause in the FTC Act. Here's the specific language.
In 15 U.S.C. Section 41, it says they may be removed by the president for inefficiency, neglect of duty, or malfeasance in office.
That is the whole shield. But to make it independent, there were 5 commissioners on 7-year staggered terms. We could have no more than 3 from one political party, and the president could fire them for only one of those 3 things. This is the template for independent agencies. The architecture of agency after agency for 90 years is basically this one sentence reprinted.
And Humphreys is what made the sentence mean anything. Without it, for cause is just words on a page if the president can ignore them.
Right. So how did Humphreys justify this shield? It drew a line. There had been a previous opinion, Myers, from 1926, that said the president can fire executive officers at will. That was about a postmaster. In this case, Humphreys comes 9 years later, and it says that the FTC was different because the FTC wasn't really doing executive work. This is what it said.
The commission's duties were neither political nor executive, but predominantly quasi-judicial and quasi-legislative. So quasi-judicial and quasi-legislative, The move was this agency makes rules like a little legislature and decides cases like a little court. Therefore, it isn't wielding the president's executive power. Therefore, Congress can protect it.
Right. That was the deal for 90 years. And the Slaughter Court, its position is that there is no such thing as a quasi-power. When an agency enforces a statute against a private party, that is the execution of the law, full stop. Roberts borrowed a line from Justice Jackson of the 1950s. Different one.
Different Justice Jackson.
Yes.
So in Trump v. Slaughter, he says, when an agency executes a congressional mandate against private parties, it exercises executive power. No ifs, ands, or quasis about it.
Right. No ifs, ands, or quasis. The FTC writes rules with the force of law, it investigates companies, and it prosecutes them in-house. The court says every piece of that is executive power. The president owns the executive power, so the president has to be able to fire the people wielding it. The four-clause protection fails.
So that's the unitary executive theory at work.
Right. So the phrase sounds academic, but it's pretty straightforward. Article 2 in the Constitution, this is the one setting out the executive. What's explicit is that the executive power goes to the president. If an officer is exercising executive power, the president must be able to control that officer, and control means removal. That's not the Constitution, that's the unitary executive theory that's doing the work in Slaughter. The FTC enforces federal law. Enforcing federal law is executive power. Executive power belongs to the president. Therefore, Congress cannot put FTC commissioners beyond presidential removal.
And the majority does not present that as a new theory.
No, it doesn't. It never mentions the unitary executive theory. Instead, it presents this as the original idea, the one the first Congress supposedly confirmed in 1789. It never mentions the unitary executive theory, and why would they need to? Who needs a new theory when you can unearth the true meaning that was always there?
There's some real Cardozo vibes in this. We've always done this, so therefore this is what we're doing, right?
Or we always should have done this.
Or we always should have done this.
Never mind
exactly.
that we didn't at all, ever.
Right. So the majority's argument isn't just about Humphrey's executor in 1935 then. It's really about 1789. The first Congress debated how Secretary of Foreign Affairs could be removed and concluded the removal power belonged to the president alone. No Senate sign-off was required. That's the decision of 1789. The court here treats it as a kind of founding era gloss on what Article 2 always meant then.
Right. They're leaning on it really hard. They say that this debate settled the question of the Constitution's meaning by the people who'd just written it. This chain of dependence idea comes straight out of Madison, that the lowest officer depends on the next, all the way up to the president, and the president depends on the people. Break the chain anywhere and accountability leaks out.
That's a pretty clean story. The problem is what it's being asked to prove. The decision of 1789 was about a single department head, one secretary, running one department. Obviously, the president's right arm. Slaughter sat on a 5-member bipartisan commission built specifically so no one party controlled it. Those just aren't the same animal.
They really aren't. And there's also the issue about what exactly they were deciding in 1789. And Sotomayor makes this clear in the dissent. The question on the floor was narrow. To remove the secretary, does the president need the Senate's sign-off? The same way the president would need to appoint that person. And the first Congress said no, that removal was the president's alone. The Senate didn't need a vote. That's what got settled. It was, you do not need permission from the Senate to fire someone. That's a really different question than, does the president alone possess all executive power in the unitary executive theory? So that's different from Congress can never protect anyone from being fired without cause. One is about who participates in a removal. The other is whether removal can be conditioned at all. The majority takes the first and reads it as the second. Shakier still, the members didn't even agree on why. Some thought the Constitution already gave the president the power. Others thought Congress was choosing to hand it over. You cannot pull a single constitutional command out of a vote like that.
So the majority says 1789 settled the removal power, and the dissent says it settled a much narrower thing, that the Senate is out of it, and not a word about whether Congress can require cause.
Right. But the Constitution never actually says who holds the removal power. The majority's argument is Article 2. The president holds all the executive power, so the power to fire comes with it. The dissent is Article 1. That's the section creating Congress. And the dissent says that Congress creates these offices, and setting the terms an officer can be removed on is part of building an office. So we're dealing with the same silence, but the majority claims this is based on a different branch than the dissent.
Okay, in Humphrey's, the court said FTC was quasi-legislative and quasi-judicial. The FTC genuinely does both. It writes trade rules and it runs adjudications with an administrative law judge and an appeal up to the commissioners. So calling all of that executive full stop erases a real distinction. Why is the label wrong?
The label was terrible, and the justices closest to this admitted as much. Robert Jackson, the Jackson we were talking about earlier, who'd actually run an agency before he joined the court, called this quasi-framing a smooth cover drawn over our confusion like a bedspread thrown over an unmade bed. Anyway, in 1988, in Morrison v. Olson, the court flatly conceded the FTC's powers. Even back then in 1935, would have been considered executive today, which makes sense since they're the powers that most agencies have.
So the rationale was shaky.
Yes, it was shaky for decades. But the court doubted the reasoning of Humphrey's, but it blessed the result anyway, by name, explicitly, over and over. In 1958, in Wiener, it held the president couldn't fire a war claims adjudicator even though the statute gave him no protection at all. The court read the protection in. In 1988, in Morrison v. Olson, 7-1, it upheld for-cause protection for an executive officer. Scalia alone was in dissent. This was the wolf comes as a wolf. In 1989, in Mistretta, it blessed the Sentencing Commission, for-cause removal and all.
And the cases people think of as the turn against it, Free Enterprise Fund, Selah Law, those narrowed it.
And you don't even necessarily need to say they narrowed it. The justices often explicitly compared whatever they were looking at to the FTC, with the FTC as the shining example of good agency structure. Free Enterprise Fund in 2010 struck down a double layer of for-cause protection. They said that double layer was the problem, but certainly a single layer, like at the FTC, wasn't the issue. In Selah Law in 2020, it struck for-cause for a single director, the single director of the Consumer Finance Protection Bureau, and Roberts wrote that the multi-member expert commissions, like the FTC, were still good law. Collins, the year after that, it's the same. So from 1935 on, the court has the exact structure in front of it again and again, and every single time it says the FTC is fine.
Until Slaughter.
Right. So before that, the rationale was contested, absolutely. But the result was affirmed by name by courts that had every chance to do exactly what this one just did and didn't. This is not a doctrine quietly rotting. It is a court explicitly saying this is a system it is fine with over and over.
Okay, but here's the majority's case. Let's forget the labels. Let's ask who really ran these agencies. 5 commissioners, nobody elected, who can't be fired by anyone the public can vote out, writing rules that bind the entire economy and prosecuting the people who break with them. For 90 years, the honest answer to who's accountable for that was nobody. The president can't touch them. Congress legislates once a decade. The voters have no handle at all. The majority's point isn't a dodge. It's that this is a hole in the democracy, not a feature of it. The Constitution puts the executive power in one person precisely because you can throw that person out, insulate the people who actually wield it, and you've built power with no leash. That objection has been gathering force since Myers, and it's a serious one that we should take seriously.
But let's follow it all the way. If the only legitimate executive is one the voters can remove, then this buffer we've been circling, the thing that kept the commissioner deciding your case from being fireable the morning of your hearing, that buffer was the problem by definition. The accountability argument doesn't trim independence, it abolishes it. It says it is all or nothing, which is exactly why the court overruled Humphrey's instead of narrowing it. So, sure, you can take the objection seriously. Just be honest that what it's actually demanding is there be no insulated decision maker anywhere in the executive branch. That's the proposition on the table, not some sort of tidy course correction.
And the price of the leash is that enforcement now swings with every election.
Right. And it's not fair to say that the FTC had no political accountability. When the presidents came in, they would appoint a new head. We would still see the majority switch to that person's party. So they're being a little disingenuous here. What we're doing now is even more extreme. It's setting up the kinds of swings that made people so upset about Chevron. That as we have a new administration come in, they clear house and start enacting their priorities. So accountability is up, but continuity is completely gone. That could be read as a repair or a wrecking ball, but nobody should pretend that this is a costless change. The dissent's strongest argument isn't even about the FTC at all. It's reliance. That Congress built on this entire line, 90 years of it, of the court's choice over and over again to explicitly bless this kind of agency structure. You don't knock out the foundation of a building people have been adding floors to since 1935.
And in most cases, that argument typically wins. It's a doctrine we refer to as stare decisis, the rule that courts stick to their own past decisions. And it's strongest exactly when the country has ordered its affairs around this central case. So how did the majority get around this?
They basically turned this argument completely inside out. The reliance interest, according to the majority, is the constitutional injury. The thing that they're being asked to protect is this thing they have explicitly held unconstitutional, and you can't rely on an illegal arrangement to keep the arrangement.
And that's clever. It's a little circular, but it is a clever argument.
So the majority would say that's why it has to be overruled. Once they've determined this was an inappropriate rule, it was never valid, this reliance was always borrowed, whereas the dissent says the opposite. So the point the liberals make is the court is treating a 90-year line of its own decisions as a single mistake, and the silence in the Constitution was deliberate. And they had settled it in a way everybody seemed to be able to function with for a century and a half. Here's a line that's likely to be pretty heavily cited.
The dissent says that the court gives the president a power unknown even to the English crown, against which the founders revolted, elevating him above his once co-equal branches by transforming a duty to take care that the laws be faithfully executed into a license to act in defiance of those very laws.
So pretty strong language. She also takes direct aim at the majority as well.
She says, perhaps worse of all, the court today forgets its place, not a doctrinal complaint, a specific targeted accusation about who decides, a separation of powers opinion that, in her telling, violates the separation of powers by having 9 justices undo what the elected branch has built and the court itself had blessed, by my count, 7 times running.
Right, that's the through line. The majority is casting itself as restoring accountability. The buck stops with one president the voters can throw out. The dissent casts it as the court tearing out its own settled law to install a theory. Whether you think that's a correction or a power grab comes down to whether the original deal was constitutional, but there really is no neutral ground here.
And just as a side note, that 7 times tally, that is Humphreys in 1935, Weiner in 1958, Morrison in 1988, Mistretta in 1989, Free Enterprise Fund in 2010, CELA Law in 2020, and Collins in 2021, all leaving Humphrey's executor still standing as the dominant law of the land. So how far does this opinion actually reach? Does every officer with any tenure protection just lose it now?
At this point, the writing is on the wall for virtually every independent agency. Slaughter says that the FTC is not a closed case. The FTC makes rules, it investigates, it brings enforcement actions, it runs in-house adjudication, and it sues in federal court. The court says this is the heartland of executive power, so FTC commissioners have to be removable by the president at will.
But the court doesn't say every protected official everywhere is now exposed.
Right, so it leaves some edges open. It says not every office Congress creates necessarily carries executive power. It flags the Federal Reserve as different because of the historical traditions of the first and second banks. And then it flags something directly relevant to this season, the tenured protection of judges for non-Article III courts.
Meaning what exactly?
The court gives 2 examples. It talks about the tax court and the Court of Federal Claims. These are really weird examples because these are not typical non-Article III courts. Those are like the adjudications that we talked about all through season 2, the hearings and the Social Security Administration, all of those things. Instead, the examples they use, the tax court is expressly independent of the executive branch. It's a weird little entity. It was set up strangely. And the Court of Federal Claims sits in the federal court system, even though its judges don't have Article III life tenure.
So when the court says non-Article III courts, it's not talking about the usual agency adjudicator.
I think it is. I'm not totally sure what they were doing. I don't know if they understood the structures of these. It looks like today ALJs are still theoretically protected, but they won't be for long. And The two examples that it cites are supposedly not part of the executive branch anyway, so it's weird they would need to explicitly say the president isn't coming after tax court judges. What is interesting is they don't even call out ALJs as a protected edge case.
That silence feels pretty loud.
It really does, because the ALJ problem is sitting right there.
So the line is not all tenure protection is dead.
Not yet, but really the line is, if you're inside the president's general administrative control and exercising executive power, Slaughter says you need to be removable at will. If you are a historically distinct institution, like the Fed, or potentially like an Article 1 court like the tax court or the Court of Federal Claims, the court says that's for another day. But for agency ALJs, the question's still unresolved, and this is also a bit of an issue because that Merit Systems Protection Board, that itself functions like the FTC. It was treated like an independent agency, and those people are now removable at will.
If a single layer is now unconstitutional for agency heads who execute the law, the obvious next question is what happens to the ALJ sitting under the two?
Right. So this is something Slaughter's teed up but hasn't answered yet. The court isn't ready to say that the judge in a benefits hearing serves at the president's pleasure. The optics are pretty bad there. And the law is genuinely harder because the ALJ is deciding the facts of one person's case. That looks less like executing policy and more like judging, but the logic is pointed straight at it. Everything we've covered about the hearing, the record, the internal appeal, all of it assumes that the person deciding has some distance from the political branches. Slaughter doesn't just take that away, it removes the theory that was protecting it. It's also worth noting that the MSPB, the Merit Systems Protection Board, which is supposed to be protecting the ALJs, is going to fall with Slaughter. The board will not be protected. So we're really now down to one level of for-cause protection, and we can say, do we even have for-cause protection if the people making that decision aren't themselves protected? So, yeah.
So the holding is narrow and the reasoning is wide.
Yes, that's the pattern of this whole line of cases. Narrow disposition, sweeping rationale, and the rationale is what the next plaintiff cites.
Okay, so let's talk about the Federal Reserve, because its governors have the same kind of protection, but the court didn't just hand the president the power to fire people who set interest rates.
That's the companion case. It was decided the same day. That is Trump v. Cook. Lisa Cook is a governor of the Fed. Last August, the president tried to fire her. For the first time in the Fed's 111-year history, a governor had been attempted to be fired. And here the stated rationale was an allegation of mortgage fraud on paperwork from before she joined the board. So she sued.
And on Slaughter's logic, she should lose. The Fed exercises executive power. It regulates banks. It issues enforcement orders. No ifs, ands, or quasis is the rule. A Fed governor is removable at will like anyone else.
Before we go further, it's worth noting that for Slaughter, he didn't try to say there was cause. Here, he did try to say there was cause, so he wasn't even trying to make this removable at will. The majority here carves the Fed out, and it told you the carve-out was coming. It told you when it allowed her to retain her position. Well, nobody else could, and it says it in Slaughter itself, too. Here's the Slaughter quote.
One example the court has given of such an entity is the Federal Reserve, to the extent that it follows in the tradition of the first and second banks of the United States.
This is their escape hatch. The Fed isn't spared because of what it does. It certainly does plenty of executive work. It's spared because of history. The first and second banks of the United States ran independent of presidential control. This is going back to Hamilton. And the court treats the Fed as the heir to that specific tradition. A historical exception, not a functional one. The result was clear, like I said, when she was the only person that the court allowed to stay at their job after the president had attempted to fire them. And it was also telling that for her, he theoretically tried to do it for cause. Again, he wasn't even trying to say that this is the kind of thing he should be able to remove at will. The question is more specifically for her, if we're alleging some for-cause removal protection, does the person get to keep their position while that's being decided?
So in Cook itself, who wins and how?
Cook wins. The vote is 5-4. The court allows her to keep her position for now. This is written by Roberts, and the reasoning is that the for-cause protection she has to mean something, and the president here didn't give her any real process. There was no notice of the evidence. There was no chance to respond before he fired her. Here's what they say.
The president's reading would turn for cause protection into little more than an at-will employment.
So isn't this funny, setting these two cases side by side? This idea of at-will employment, this is what Slaughter did to every other independent agency the same morning. For the FTC, for cause becomes at will. For the Fed, the court refuses to let it.
So they saw the choice cleanly. The one door said the Fed is just another agency and the president can clean house. The other says the Fed is unique, and they picked unique. And Kavanaugh basically admitted they had to in a concurrence because leaving it ambiguous would itself spook the markets.
So that's the real critical point here. This reads like an opinion written by people who could picture the bond market if they got it wrong. The Fed doesn't really survive on any sort of principle that scales. It survives because it's the Fed. And the principle is actually so important that they released both of these opinions simultaneously, presumably to reassure everyone. Normally, they would have released each one only when it was being read in chambers. So doing them at the same time, because Slaughter was coming first, meant that there wouldn't be some point where the markets panicked thinking the Fed was going down.
Okay, so does Cook actually protect the governor, or does it just slow down the president? I mean, if he can fire her later with the right paperwork, that's a process win, not a substantive win.
Right. Really, she has a process win. This is a preliminary decision. The court doesn't say the president can never remove Cook. It just says he has to do it the right way. He has to give her notice of the evidence, a genuine chance to respond, a deadline to do so, and the cause has to actually imply she's unfit for the office with some nexus to her duties, not just some pretext to swap in someone friendlier. Do that and he can try again. Barrett, in dissent, reads this as written to block him from refiring her over the mortgage allegation at all, and accuses the majority of trying to paper over that. So here, even the size of Cook's win is contested. That could lead some people to say this is so preliminary that we can't really compare these two. But the court made clear that here the process does have to be followed, and she is potentially protected. She is protected by for cause. We're just not totally sure what this cause could be. So it's doing more than some people are claiming. If the Fed didn't have for cause protection, she's not entitled to any process. She can be fired just like every other independent agency official. And for the administrative state, this matters. It matters less whether her particular mortgage fraud allegation would count as for cause, and more just that there is the existence of a requirement of for cause protection.
So for cause survived at the Fed.
There's still something there, and not nothing is now the most protection that any officer in the federal government has against being fired. That's the measure of the day. This also shows how important judicial review is, and we'll talk about that in the next episode. Here, Cook is able to have her case reviewed because the court is willing to review whether the proper procedures were followed.
Okay, look at the justices. In Slaughter, 6 justices in general agency independence. In Cook, 5 say the Fed. Roberts is in both majorities. Kavanaugh is in both majorities.
So the 3 Slaughter dissenters, Sotomayor, Kagan, and Jackson, cross over to join Roberts and Kavanaugh and Cook. So the Cook majority is the 3 liberals plus Roberts plus Kavanaugh. The 4 who would have let the president fire Cook are Thomas Alito, Gorsuch, and Barrett.
So Roberts and Kavanaugh are the whole ballgame. They voted to end independence as a general matter and preserve it for one institution. That is not a contradiction if you think the Fed is generally one of a kind, but it is a narrow ledge.
A very narrow ledge. Barrett is pointing right at it. In Cook, she says that this holding is in serious tension with Slaughter, which it obviously is. Slaughter announced what Barrett calls a categorical rule. When an agency executes a congressional mandate against private parties, it exercises executive power, and it has to be under presidential control. No ifs, ands, or quasis about it. But then Cook turns around and recognizes a Fed exception sanctioned by history.
So her point is the court is trying to have both things at once. If the rule is categorical, then the Fed should lose. If history can override the rule, then the rule is not categorical. Barrett asks it directly, how can history support both a categorical rule and a carve-out? And when she asks whether the Fed is actually unique or whether history might sanction other exceptions too, her answer is blunt. The court does not say.
So then Gorsuch says, look at what we just did. He joins the Slaughter majority. He agrees that officers exercising executive power have to answer to the president. But he also says Congress has given independent agency vast legislative and judicial powers too. the power to make rules, to decide disputes, and after Slaughter, the president can effectively exercise all those powers too.
So the problem is not just the president controls enforcement.
Right. The problem is that Congress built these agencies on the premise that they were insulated, a premise that would have been really reasonable given 90 years of court historical precedent saying exactly that. Now Congress may have delegated power under one assumption, and the court has changed that assumption. The rules, the prosecutions, the adjudications, all of it now runs through people the president can fire.
Which makes the delegation question unavoidable.
Right. That's what he's saying. Would Congress have delegated so much legislative and judicial power to independent agencies if it had known the president would control them? And even if Congress wants to pull that power back now, he says there's a ratchet effect. This power that Congress delegated by simple majority could now take a veto-proof supermajority to retrieve.
So independence was not decoration, it was the price of the delegation. Take it away, and the bargain Congress struck starts to look something that Congress may never have agreed to. So can I ask you, before we close out today, what your take on the cynical view of the difference between Cook and Slaughter is? So there's at least some smoke, right? You hear this concern about markets with Roberts and Kavanaugh, that we could look at these two cases and say, well, the biggest difference between these two cases is that Roberts and Kavanaugh have a 401k and that the Federal Reserve is directly going to impact that 401k. Is that too cynical to think of these two cases?
So it is definitely a view that a lot of people are taking. And there is no question we are protecting the Fed because we are concerned about what's going to happen to the markets if we don't. Not just the markets, the entire national economy. We do not want to let Trump be in charge of interest rates. I mean, catastrophic. So there are real practical reasons why we need to do this. What's actually kind of more interesting is how many of the conservatives weren't on board with it. You'd think that if this is really just personal financial benefit, they would all be jumping on board. But aside from the two who switch sides, we really have pretty principled positions. All the liberals say, this is absolutely a valid agency structure. We've done this for decades. We should keep doing it. And a lot of the conservatives say, no, we absolutely want to hand the president total control over everything. There are way more people than you would think who are totally on board with that idea. It seemed pretty clear from early on that they were not going to touch the Fed, that would just be nuclear, essentially. So it wasn't surprising that it was protected, but it was kind of surprising that it was protected by such a thin majority.
So, all right, as we wrap up, I mean, Humphreys is 90 years old and it lived a good life, but it died on Monday.
Right. And it died next to a case that saved the one institution it would have hurt most to lose. That's the pairing to remember. Slaughter and Cook. Same day, same Chief Justice writing both. One ended independence as a general rule. The other proved that the court will protect independence when it decides the stakes are high enough. But only for the Fed, and only on a tradition that it falsely claims runs back to Hamilton's bank.
And Rebecca Slaughter herself?
She doesn't get her seat back. Lisa Cook keeps hers, at least while the case continues. We had two officers fired by the same president, two opposite results, and the line between them is just the institution they're sitting on.
But Cook is doing something else as well.
Right. Cook isn't just about the Fed, it's about review. The president said, I have cause. The court says that can't be the end of it. A court has to be able to ask whether cause means cause, whether the officer had a real chance to answer, whether the process was real or just paperwork, whether it's valid to say this over social media. This is covering a decision that was already made.
So the judicial review then is the safeguard.
Right. And that's the point. Once that independence is gone, once the president controls the agencies directly, the remaining check is supposed to be the courts. If the executive takes something from you, we need this promise that someone outside the executive can still ask whether the government at least followed the law.
And that's where next time starts.
Right. So in Cook, the court said that review matters when the president removes a Fed governor. But in Mullen v. Doe, the court says something very different when the executive terminated temporary protective status. The statute required process, it required consultation, it required the government to look at country conditions before cutting off protection for people who had been living here lawfully for years.
And the claim was that did not happen.
Right. That's the other half of the story. In Slaughter, independence falls. In Cook, review saves the Fed. And in Mullen, what we're talking about in the next episode, the court shows what happens when The last check on that executive action disappears too. The executive acts, the process is challenged, and the courthouse door is locked before any judge can ask whether the law was followed.
So that does it for today's episode on administrative remedies. Thank you for joining us today. Please, if you enjoy this podcast and enjoy this episode, give us a like on Spotify, iTunes, or whatever platform you're listening on. And be sure to tune in next time where we'll continue to dive into the contours of administrative law because remember, you can't fix what you don't understand.